check from the department. I'll start with the DOJ. Is the department represented here? DG?
Yes, Chair. I'm here with senior officials department, and I wanted to also just beg for your indulgences. Place as well, I needed to make some comments in another meeting, but I'm here with the colleagues, senior managers.
Thank you very much, and your network is better today. Thank you. Do we have SAPs in the meeting?
Good morning, Honorable Chair. It's Major General Assessor from SAPS, and I'm also made aware that our colleagues have also been invited, and hopefully they have joined the meeting from Detective and also Vispo. But myself and also another brigadier from Legal Services, we are present. Thanks.
Okay. Thank you. Maybe just before I proceed to the next department, just to explain, Honorable Breitenbach, you're asking an important question whether we should not elect a chair. We did that yesterday, and the explanation was that the chair won't be available yesterday and today. So that's why I just continued. I hope that assists clarifying the matter, Honorable Breitenbach.
Well, not really. I wasn't there when you elected the chair yesterday. I joined a little later, and so if the chair was elected for yesterday and today, that's fine. That was clear. If it's not clear, we need to elect a chair for today.
No,
that's just what the process requires.
It was clarified in terms of the apology. He was not going to be available today as well.
Yeah, I'm not interested in so much in the apology as in the election process.
Thank you, Honorable Breitenbach. Can I get to the Department of Basic Education?
Good morning, Honorable Chair.
You're present. You are here.
I am here.
Okay, thank you. Department of Social Development.
Morning, Chair. I'm here. Caesar Maham.
Okay, thank you. Legal aid.
Good morning, Chair. Deep Kubana here from Legal Aid South Africa. I'm here.
Thank you. The NPA.
Good morning, Chair. Advocate Kari Gamu here from the soccer unit of the NPA, as well as Advocate Piers Smith and Advocate Vuyo Katelo. Thank you.
Thank you very much. Department of Correctional Services.
Good morning, Chair. The Department of Correctional Services is represented by the Deputy Commissioner, Vuyi Mlomondlovu, who is responsible for remand operations management. He's also responsible for the implementation of the Child Justice Act in the Department of Correctional Services.
Thank you. Department of Health.
Good morning, Chair. Department of Health is present, represented by Dr. Pinini from National Department of Health.
Thank you very much. That's very helpful. All the stakeholders are present here today. We really appreciate that. Can we have the presentation? And I guess DOJ will lead the presentation.
Chair, Swart here. I've just got my hand up. I just need to note my apology. I need to leave a bit earlier for the Chief Whip's forum. My apologies in advance. Thank you.
Sorry, I did not see the hand. Apologies. We welcome that. Thank you, Honorable Swart. When that time comes, just walk out. Thank you for that. Can we proceed with the presentation?
Chair, good morning, and honorable members, good morning. We'll ask Dr. Charmaine Badenhorst, the Director for Child Justice, to take us through the presentation. Charmaine?
Good morning, Honourable Chair and Honourable members of the committee, DG Dr. Shabani, as well as the government stakeholders present on the platform. First, before I start, I want to just thank the committee for the opportunity to brief and present on the Inter-departmental annual reports on the implementation of the Child Justice Act. Can you move the slide? Should I move the slides or, oh, thank you. So in the presentation, we're going to provide progress on the implementation of the Act by the various government stakeholders that are present on the platform. The focus will be on the 2020-2021 departmental annual reports tabled by the Minister in terms of Section 96.3 of the Child Justice Act. We will highlight achievements and challenges experienced in the implementation of the Act and elaborate on future actions to address these challenges. Before I start the presentation, it is important to note that the COVID-19 restrictions variably impacted on the usual patterns of crimes nationwide, and the country recorded a significant reduction in crime figures in general, and this was also evident from the crime data of children in conflict with the law. The performance of the current reporting period compared with the previous reporting periods will therefore show downscale outputs with limited value, and hence there's a need to view this report through a COVID-19 lens, taking into account the aggressive impact of the alert levels of the national lockdown on government performance and the socio-economic landscape in the country. So Section 94 of the Act established the Intersectoral Committee for Child Justice with the responsibility to monitor the implementation of the Act and the National Policy Framework for Child Justice. The stakeholders who are also members of this committee and submitted report on the implementation are depicted on this slide, and through the introductions we established that all of them are present in this briefing. Next slide, please. So if we look at the governance structures of the Child Justice Act, we have the Directors General Intersectoral Committee established by Section 94 of the Act. We refer to it as the Director General's Intersectoral Committee, since the members of this committee comprises of the Directors Generals of the various departments, the National Commissioners of Police and Correctional Services, as well as the National Director of Public Prosecutions. We've also established a National Technical Intersectoral Committee, which comprises of senior officials from the various government departments, implementing government departments and institutions. And then there's also Provincial Child Justice Forum in all 9 provinces, which duplicates the structures, the aforementioned 2 structures. All these structures are chaired by the Department of Justice and Constitutional Development, and the department also provides the secretariat functions to all 3 of these structures. So if we look at the Directors General Intersectoral Committee, we have the various implementing departments and institutions. We've also co-opted legal aid into this structure to ensure that we have all the role players essential in the implementation of the Act. The judiciary also have a representative on the structure as well as the integrated justice system. Civil society organizations are represented at the National Technical Intersectoral Committee and at the provincial fora. So the National Policy Framework sets out implementation priorities and strategies to measure the country's progress on the achievements of the aspirations of the Act. And the National Policy Framework identified 12 key priority areas which is utilized for reporting to measure the progress in terms of the implementation. The 12 priority areas are capacity building, methods of securing attendance of children in preliminary inquiries, assessment of children, preliminary inquiries, diversion services, which comprises of both the application of diversion and the provisioning of diversion services, awaiting trial, bail and placement, trials, sentencing, infrastructure management specifically for the implementation of the Act, resources, public education and communication, and the integrated information management system. Next slide, please. The next slide. Yeah, thank you. So I've structured this presentation to follow with the key priority areas to follow the flow of children through the child justice system, to give an understanding of what happens to children while they are going through the system. And the other key priority areas will be dealt with at the end of the presentation. So the first area that we will focus on is the best methods of securing attendance of children at preliminary inquiries. So the police reports on the number of charges against the children, and during the reporting period 2020 to 2021, 23,663 charges were brought against children. And we can see that from the implementation of the Act, there's been a significant decrease in the number of charges against children, but research shows that there is international decline in child offending. So one child can be charged on multiple charges, and multiple children can be charged on one charge. So the South African police now also provides the number of children charged for us to be able to track the numbers of children going through the system. In 2020, 2021, 26,789 children were charged by the police, and the decline in the number of children entering the system is also clear from this slide. Next slide, please. The following areas I'm going to focus on is assessments, preliminary inquiries, and diversions. So the Child Justice Act requires that all children who are arrested or apprehended by the South African police must be assessed by probation officers in the employment of the Department of Social Development, unless the assessment has been dispensed of. So in 2020-2021, 6,979 children were assessed. And if we look at the table from 2015, there has been an overall decrease in the number of assessments of 16,808. As I stated, the prosecutor and all the magistrate can dispense of assessments, but I think this is where the impact of COVID is clearly visible in the reduced number of children entering into the system. Next slide, please. The next one is preliminary inquiries. So a preliminary inquiry is an informal pre-trial procedure that is inquisitorial in nature. The Department of Justice and Constitutional Development provide administrative support during preliminary inquiries, and the data that we collect help to determine the profile of children who commit crimes and also assist us in the trend analysis to ascertain the crimes that children commit. During the last reporting period, there was a 39.95 decrease in the number of new preliminary inquiries recorded compared with the previous reporting period. And this again shows the impact of the national lockdown. Next slide, please. At the ages of children in preliminary inquiries, we can see that only 44 children aged between 10 and 11 years appeared in preliminary inquiries during the reporting period, and this represented 0.5% of the total number of preliminary inquiries that were registered during this period, and 17-year-old children appeared in 39% of the new preliminary inquiries recorded. Next slide, please. This slide depicts the percentage change in preliminary inquiries registered per age. So we can see that in all ages, reductions in the number of new preliminary inquiries were recorded. The percentage reductions recorded for 10 and 11-year-olds were much higher in comparison to the other groups, and this may be due to the fact that they were under the supervision of their parents, guardians, or caregivers, who were mostly at home during the national lockdowns. Compared to the others, children aged 13 reported the lowest percentage decrease in the number of new preliminary inquiries. Next slide, please. So the outcomes of the preliminary inquiries depicted on this slide. 53% of the children that appeared in the new preliminary inquiries during the reporting period were referred to the Child Justice Court for plea and trial, with the 16 and 17-year-olds comprising of the majority of these children. 25% of the new preliminary inquiries that were reported during this reporting period were diverted. Next slide, please. This is the top 10 crimes registered in preliminary inquiries. So from this slide, it is clear that assault with the intent to do grievous bodily harm continued to be the top charge committed by children appearing in preliminary inquiry, and we can see this trend from 2015-2016. It is noted with concern that the second top charge was rape, which contributed to 16% of the total number of charges at preliminary inquiries, that is something that we as a sector and as a country should address and prevent. Thank you. Next slide, please. So if we look at the percentage change of the top 10 charges during preliminary inquiry from the previous reporting period until the current reporting period, there has been a substantial increase in the number of 55% in the number of rape charges against children that appeared in preliminary inquiries, but there was also a significant drop in the number of charges of possession or use of drugs from between the two reporting periods, and this must be linked to the Gauteng South High Court judgment in the case, the state versus LM, and 3 others, where the Gauteng High Court on 31 July declared Section 4B of the Drug and Drug Trafficking Act inconsistent with the Constitution and invalid to the extent that it criminalizes the use or possession of cannabis by a child. The court also ordered that pending the completion of the law reform process, that a child may not be arrested or prosecuted or diverted for contravention of this specific section, but also then highlighted that the moratorium does not prevent or prohibit persons from making use of civil processes to ensure that children receive the necessary assistance and support for interventions for cannabis dependency. Next slide, please. Legal services provided to children in preliminary inquiries by Legal Aid South Africa is displayed on this slide. Section 81 of the Act makes it clear that it's not compulsory for a child to be legally represented at the preliminary inquiry, but states that nothing precludes a child from being represented by a legal representative. The Legal Aid South Africa does not have dedicated capacity to provide its services during all the preliminary inquiries, but they do offer support in cases where it's deemed necessary for children to be legally represented in the preliminary inquiry stage of the proceedings. During the reporting period, 1,208 children were legally represented by legal aid in preliminary inquiries. Next slide, please. Diversion plays a central role The diversion of child offenders play a central role in the Act, and the Act provides for the possibility of diversion in all matters. There is no exclusion from the possibility of diversion based solely on the nature of the offence, and any child accused of any crime can therefore be considered for diversion if it is desirable in the circumstances. During the reporting period, 2,187 children were diverted by the National Prosecuting Authority, and this reflects a 47.1 decrease compared to the previous reporting period. The feedback from the lower points indicated that this is due to the fact that fewer children entered the criminal justice system due to the COVID-19 pandemic. Next slide, please. The number of the NPA also reports on the number of diversions before preliminary inquiries and during preliminary inquiries, as well as diversions for Schedule 3 offences. Schedule 3 offences in terms of the Child Justice Act refers to the most serious offences like murder, rape, robbery with aggravating circumstances, etc. So during the reporting period, we can once again see that there was a decline on the numbers of diversions during all three of these instances displayed on the slide, with 300 children diverted before preliminary inquiry, 1,326 during preliminary inquiry, and 69 were diverted after they've committed Schedule 3 offences. Next slide, please. Thank you. The Act promotes the use of alternatives to detention which are in line with our Constitution and the provision that children should only be detained as a measure of last resort and for the shortest appropriate period of time. The Act allows for various releases of children which includes bail. From this slide, we can see that during the reporting period, 71% of the children were released awaiting trial, were released in the care of their parents, guardians, or appropriate adult, with 18% were detained in child and youth care centres and 1% in correctional facilities. 341 were released on warning. Thank you. If we look at the ages and where the children of different ages were placed during awaiting trial, we can see that the 10-year-old that were awaiting trial were released in the care of his parents. The majority of children that were detained awaiting trial in child and youth care centres were the 16 and 17-year-olds, and this is also applicable to those that were awaiting trial in correctional facilities. Next slide, please. The top 8 charges against children awaiting trial. From this slide, we can see that rape comprised of there were 1,024 charges of rapes against children, which contributed to 22% of the overall charges against children awaiting trial, followed by the assault with the intent to do grievous bodily harm. Murder was in the 3rd place, and the contribution for murder was 8%. Thank you. So if we look at the predominant charges allegedly committed by children awaiting trial per province, we can see that in the 3rd column depicts the total number of charges against children awaiting trial. And from that, we then looked at what is the predominant charge against children per province. So in Mpumalanga, Northwest, Limpopo, Eastern Cape, Free State, and KwaZulu-Natal, the predominant charge contributing to the percentages on the left-hand side was rape. In Gauteng, it was assault with the intent to do grievous bodily harm. In Northern Cape, it was housebreaking with the intent to steal and theft, which comprised of 19% of the overall charges. And in Western Cape, it was also assault with the intent to do grievous bodily harm. And those three charges referred to in that slide comprised of 24% of the overall charges against children awaiting trial for this reporting period. Thank you. So if we then look into those predominant charges from the previous slide, we can see that rape being the top charge in all the provinces that I've mentioned, that the children who commit the most of those crimes were between 10 and 16-year-olds, and then with the top charge against the 17-year-olds was the assault with the intention to do grievous bodily harm. This is just a given indication of what crimes are children committing at what ages, so that it will assist us in developing interventions to ensure that we prevent children from entering the criminal justice or the child justice system. Next slide, please. So if we look at the children awaiting trial in correctional facilities, this is the average number of children that awaited trial in correctional facilities. During the reporting period, there were 49 children in awaiting trial in correctional facilities, and it shows a huge decline from the period 2015-16, where there were 99 children awaiting trial in correctional facilities. From the annual report of the Department of Correctional Services, they've indicated the decrease from the numbers before the implementation of the Act, and the table in the annual report can clearly show the impact that the Child Justice Act have had on children being detained in correctional facilities awaiting trial, as well as on sentenced children. Thank you. The next stage and priority I'm going to focus on is trials. We have looked at the ages of children who appeared in child justice courts during the reporting period. We can clearly see that the majority of children that were appearing in child justice court were 16 and 17-year-olds, with only one 10-year-old and 9 11-year-old children that appeared in child justice court. The decrease in the number of children that appeared in child justice court is also linked to the decrease in the number of new preliminary inquiries reported during the reporting period. Next slide, please. We also report the outcome of trials and the decline, as I stated, the decline in new preliminary inquiries then registered a 35% decrease in the number of cases referred to child justice court, and this also impacted on the number of outcomes recorded in child justice courts. There were fewer outcomes of diversions, and this may be due to the fact that the diversion programs could not proceed as usual due to the COVID-related restrictions. So we can see here that 125 children were convicted. A number of cases were struck off the roll, some were withdrawn, and as I stated, the diversions also decreased. Next slide, please. Legal aid provides representation to children during trials in child justice court, and Section 83 of the Act prohibits a child from waiving his or her right to legal representation when appearing before a child justice court. Legal aid represented 4,988 children in child justice court during the 2020-2021 reporting period. So then next we zoomed into the top 8 charges that children were convicted of. From this, we can see that no children below the age of 13 were convicted of any crime in the child justice court. The top charges that children were convicted of was housebreaking with the intent to steal, followed by by assault with the intent to do grievous bodily harm. Despite the fact that rape was one of the top charges against children awaiting trial reflected on earlier, only 12 of them were convicted of this crime during this reporting period, and this may be linked to the the challenges experienced by the South African police laboratories regarding the delayed release of DNA reports. So if we then look at the sentences that were imposed on children following their conviction, and we can see that just want to take some notes, sister. All right, so in this regard, 66 sentences, in 66 instances, children were imposed a postponed sentence or a postponed of the passing of a sentence or a suspended sentence. And this kind of sentence acts as a deterrent for children to keep on committing crime, because usually the court attached conditions to the postponement or the suspending of the sentence, which will then come into operation as soon as the child commits another crime. 20 children were sentenced to compulsory residence in a child and youth care center, and 25 were sentenced to imprisonment. So if we look at the types of sentences that were imposed on children per age, the majority of children sentenced to imprisonment were the 17-year-olds. 2 children aged 14 were sentenced to imprisonment, and 80 of the 125 sentences imposed were community-based sentences, which is again in line with the constitutional principle that children should only be detained as a measure of last resort. Thank you. So then if we look at the top 8 convictions where imprisonment were imposed, the crimes that children committed to be sent to imprisonment, we can see that the 14-year-old was sentenced to imprisonment for housebreaking with the intent to steal and theft, as well as rape. The majority of 17-year-olds were convicted of housebreaking with the intent to steal, murder, and robbery. So this just gives us an idea of what crimes children were committed and then be sentenced to imprisonment. Thank you. So if we look at this, the children that are sentenced children that are in correctional facilities, the average number of children sentenced decreased from 187 in 2015-16 to 40 in 2020-2021, and this represents a decrease of more than 21.4%. The department also monitors appeals and reviews through the NOC-INT to ensure compliance with the provisions of the Act, especially the provisions in relation to automatic reviews for specific sentences. We can see that there's been a reduction in the number of reviews recorded, and this may be linked then to the overall reduction in the number of trials that were finalized in child justice courts during the reporting period. The South African Police also reports on the number of charges of sexual offences allegedly committed by children. We can see that in the reporting period 2020-2021, there were 2,175 charges of sexual assault against children, and the decrease from the previous reporting period were also been then linked to the decrease in the number of children that entered the system through the South African Police Service. In the next slide, I'm going to focus on some of the other key priority areas. The first one is capacity building or building of skills and capacity. The Act, Section 97 of the Act acknowledges the importance of skills development and requires the Department of Social Development, the Department of Health, the Department of Correctional Services, as well as the South African Police to develop training courses with social context training so as to enable the personnel to deal with child justice matters in an appropriate and efficient and sensitive manner. So from this slide, we can see the numbers of training. I was just alert the committee that I've realized that with regard to the number reported by the Department of Justice for the 2020-21, that is a mistake. 113 officials were trained during this reporting period, and that will also then impact on the total on the slide below. But that is just a typing error or mistake that crept in. Thank you. So another key priority area is the management of infrastructure for the implementation of the Act. So there are currently 3 one-stop child justice centre operational in the country. It's the Lorena one in the Eastern Cape, the Mangaung one-stop child justice centre in the Free State, and the Matusana one-stop child justice in the Northwest. The Department of Social Development manages 31 child and youth care centres that have a best capacity of 2,295. And children were detained in correctional facilities. Those awaiting trial were detained in 12 different centres, correctional facilities, and those that were sentenced are detained in 8 of the correctional facilities. So, the next slide is the key priority area that relates to the development of integrated information management system. IJS, the IJS Transversal Hub provides a technical integration platform for electronic exchange of information between all the various member departments. And the JCPS cluster was the first cluster within government that pursued the interoperability. And the hub already provides electronic exchange of information between police, the NPA, the Department of Justice, legal aid, correctional services, and the Department of Social Development for the purposes of child justice. Next slide, thank you. So we've just highlighted some of the key achievements of IJS, of the IJS program. The IJS and DSD completed the enhancement and the development of an updated version of the DSD mobile probation case management application. They've also updated the South African Police's integrated case management case docket management system to reflect the name, the contract number, and the estimated time of the arrival of the assigned probation officer. And this will enhance the data completeness and improve the monitoring to ensure that all children that are apprehended by the police are brought to the attention of the Department of Social Development for the purposes of assessment. The mobile probation case management system or application also provides for automated escalation alerts. So to the DSD provincial management. So in cases where the probation officer have not responded in predetermined time in intervals, then the application will push a notification and SMS alert to supervisors of the probation officers to ensure that there is enough time for the children to be assessed before the cases are referred to the prosecutor for decision on whether or not to proceed with the prosecution. And IJS also manage the electronic integrations between SAPS and social development. And there's an interactive reporting dashboard that provides key metrics for the number of children that were apprehended by police and the response rate of the DSD probation officers and supervisors in attending to these notifications. In this slide, I'm going to focus on some of the challenges and possible solutions. So, despite all the efforts that the Intersectoral Committee for Child Justice have done to eliminate discrepancies in the data and in the annual reports, we still experience discrepancies, especially with regard to the number of children charged, the number of children assessed, the number of assessments, the number of children appearing in preliminary inquiries, the number of children charged, and the number of children who appeared in preliminary inquiries, as well as those who appeared in child justice courts and those that were represented by Legal Aid South Africa, to name just a few. And there's also no record, or it's not reported on, where the prosecutor make the decision to decline to prosecute before the preliminary inquiry, and that then resulting in the children not being recorded in the preliminary inquiry, but nowhere else. And also, what is the reasons for those decisions? So those are issues that we, as a sector, are still grappling with. And the Intersectoral Committee have taken some steps and interventions to try and close these gaps, which are depicted on the next slide. So before I go to the interventions, we have established a task team to physically take samples of these cases where we find, where there are discrepancies, to try and ascertain why these gaps exist. And in some of the cases, we found that when a person is apprehended by the police, the person either deceives the police, the police official, or the police accept or estimate that this person that they have arrested or apprehended is a child, and then they will register that person as a child on the CAS system. And when it later transpires that the person is in fact over 18 years, the CAS system is not corrected to reflect the older age, and those children then are continuously being counted as children entering into the system. We've also ascertained that assessments are not conducted before the court appearance. So what we've noticed is that in some instances, probation officers will wait at the court to see whether the prosecutor is going to proceed with the prosecution or not. And only in the cases where the prosecutor decides to proceed and refer the matter to the preliminary inquiry are assessments being done. And that can also then assist with explaining why there's such a huge discrepancy between the number of children charged and the number of assessments conducted. Also, as I referred to earlier, cases where prosecutors decline to prosecute before the preliminary inquiry are not recorded or reported on. So, because that will also close the gap for us to indicate, why are few children going through preliminary inquiries, whereas many of them were arrested by the police. The SAPS data system does also not provide for a field of knowledge prosecute or decline to prosecute decisions by the prosecutor, and those are then recorded when the docket comes back to the police station as cases withdrawn, where in fact there was a decline to prosecute. Next slide, please. So if we look at the interventions that we have started to try and address these gaps, first it's the systems integration between the integrated case management system child justice module, ICMS Child Justice, and being managed by the Department of Justice and Constitutional Development, and the electronic case management system, the ECMS system, managed by the department, by the National Prosecuting Authority. So currently, there's a systems integration between police, the National Prosecuting Authority, and the Department of Justice in relation to adults entering the criminal justice system. But with regard to children entering the system, the Department of Justice is not included in this systems integration. So what this means is that cases are pushed from police, from the CAS system to the ECMS system of NPA, and then nothing happens because they cannot be pushed. There's no link between the ECMS and the ICMS child justice system for these children then to be pushed through to the department's case management system. We have developed the specifications for this integration, and hopefully we will be able to prioritize this in the current in the next financial year, just because that will eliminate a lot of the gaps of children disappearing from apprehension to appearing in preliminary inquiries. And with the integration between police and social development in relation to the assessments being ensuring that assessments are being conducted, we would have made huge strides then to try and be able to trace all these children electronically through the system. Whilst we are waiting for that, we've also started with a data verification process at provincial level, where, as I indicated earlier, cases, samples of cases are drawn from the court, the police docket is obtained, as well as the information from the Department of Social Development to see whether those cases went through all the processes and were reported by all the different stakeholders to ensure that that we can account for all children moving through the system. This project is still in progress, and the provincial chairpersons of the provincial structures do provide progress reports on a quarterly basis to the national technical team to then engage in some of the gaps that they have identified and to close them. We have also amended the National Policy Framework on Child Justice in 2018, where we have elaborated in great detail under each priority area on what each stakeholder should report on and what data they should be providing in their annual reports. So I'm sure that the committee, having read the annual reports by the various stakeholders, have noticed that there's a wealth of information available in all these annual reports, and it's very possible to then get an idea of the crimes and the trends of crimes that children commit and the way that they move through the child justice system. And then, as I referred to earlier, the systems integration between police and the Department of Social Development, which will then carry the notification of apprehended children to ensure that they are all assessed. The next slide.
Maybe just, sorry, just before you proceed, it's over an hour now presenting. How far are you from wrapping up?
Thank you, Chair. It's basically just 2 slides. I've dealt with most on this slide, so we can skip to the next slide.
Okay.
Thank you. So another challenge that was highlighted was the access of police to the diversion register. The police is currently consulting with DSD to address this challenge. There's also a lack of training of police members on the Act, and this will commence. It was interrupted due to COVID, but it will commence. The DSD reported that there is a lack of participation of children in formal education in the correctional facilities, and they will be conducting an audit to find out why children are not participating in the formal education being provided, and then interventions will be developed to address this. And then also DCS, because of the few children in DCS facilities, there is a lot of, I see in the presentation it says lone children, but it's supposed to be alone children, where because there's few children, they often find the situation where a child is being detained and is the only child in the facility, and they have developed a process where these cases can be referred back to court for consideration of alternative placement where possible. Thank you, Chair.
Thank you. Thank you for the presentation. Quite comprehensive, understandably so. That's appreciated. Honorable members, can I invite you to interact with the presentation? I see Honorable Breitenbach, followed by Honorable Horn. Those are the hands that I have. Nomatemba Maseko Jele, Velma Nivot, Homotora Mulbeng, in that order, colleagues. Honorable Breitenbach.
Thank you, Mr. Acting Chairperson, and good morning to everybody. I don't have a record of the slide numbers, so I'll just ask the questions generally. I'd like to know if there's some sort of record of recidivism amongst child offenders, and if so, what is the percentage? I'd like to know what percentage of children who are referred for deviation or have their, I forget now what the phrase used was, but to have their charges withdrawn on the basis that they don't reoffend. How many of them actually do reoffend? How many of them come back into the system as well? And then I'd like some information on the time it takes from an arrest and notification of a child in custody to a social worker arriving to assess the child. What is that time frame? And then I'd like a little bit more information about the children convicted or not convicted, acquitted of rape, charged but not convicted. And the suggestion was that it may be as a result of the delay in DNA analysis from the police. Well, it may be, it may not be. What is the position? Is it as a result of the DNA delay? Is it as a result of the analysis not being done? Is that information not available? Because if that's the case, we need to do something about it. That's totally unacceptable. But I must say that I find it extremely worrying that we're sitting here looking at a graph of children under the age of 17, and some of them as young as 14, being caught up in assault with intent to do grievous bodily harm, murder, and rape. That is so concerning to me. Regardless of whether they're charged, convicted, that's a different issue altogether. Just how did we get here as a society where children under the age of 17 are busying themselves with this kind of activity? We need to look at different solutions. The solution is not putting them all in jail. We need to find a solution that prevents them from landing up there in the first place. So I'd like to hear some views on that. Thank you, Mr. Acting Chair.
Thank you, Honorable Breitenbach. I hope all the departments and the lead department, you're taking notes on all the issues raised, because we want you to respond to all of them. Honorable Hon.
Yes, thank you, Acting Chair. The presentation firstly makes mention of an amendment to the National Policy Framework in 2018 to clearly indicate the responsibilities of all partner departments, etc. Our researchers, however, have advised that the policy framework on the website is still the one of May 2010. So, well, firstly, I think it's advice to the department to update it, but secondly, I think given the fact that it is not a published policy framework, we must ask the department to what extent then is there a public advocacy program to also enable those who must receive services on the back of this policy framework as to what they are entitled to and can expect. Then, in respect of the duty which we were advised, acting chair, is an absolute duty that children who are taken into custody or are apprehended must be subjected to a process of a preliminary assessment. And even though we bear in mind the impact of COVID, it would seem that in 2019-20, only 60% of children who were apprehended were assessed. And in the following year, this dropped to 26%. And I think the question must be asked whether that really can be ascribed only to the COVID-19 pandemic. By then, obviously the lockdown levels were to the effect that one would assume these DSD service providers or officials were able to perform their duties and tasks. So we must, I believe, ask the question, what is the way forward to correct this, and whether there was any additional measures to ultimately assist those children who did not go through the assessment, and what was the knock-on effect of those assessments not taking place. And then the last question I want to ask, acting chair, is around the amendments to the Child Justice Act. The amended regulations were tabled by the minister yesterday, and we of course all recall that had to do with the amendment legislation this committee also dealt with around the age of criminal capacity. So I want to hear from the department and really all of the departments, what processes have in the meantime unfolded. I would assume they were heavily involved with the drafting of the amended regulations, and what other processes have in the meantime ensued to position them for immediate implementation once these regulations are approved by Parliament. Thank you.
Thank you, Honorable Horn. Honorable Mamatemba Maseko Jele.
Thank you, Chairperson. Good morning, colleagues, and our visitors, Chair, and we welcome the presentation. Only 2 or 3 questions, Chairperson, that I have to this. The first one is directed to all the departments. We are informed that the technical team will be represented by officials at the senior level. I wanted to find out how senior level that is going to be represented. Is it the director? Is it the supervisor? Is it the managers and all that? That is the first one, Chair. The second one, it is about, I'm sure this one will be directed to the social development. It is about the families of those children. It's more or less like the one that I asked yesterday, but this one, do we have information as to, because we want to also manage where these children are coming from. The kind of setup of families of these children that are involved. Is it single parents, both parents, orphans, or children which are child-headed families that are involved in these activities? Chair, I would really love to have information on that one. Lastly, Chair, it is on the challenges. I'm sure my yesterday question still stands, Chairperson. I think we will have going forward to monitor the answers that we get from the department, because there's a new tendency of not answering our questions. And it's not the first time. I think, Chair, I would like the chairperson to note that, because I still have that question of saying we are the lead department here. And I want to know, because they are going to meet, as they have indicated that they have this technical committee, as to how is the department going to manage that group. Because, Chair, we cannot come here only to find that some other things that we have raised in the previous meetings, and the department must monitor all those things and make sure that whatever that we have done, we have asked, when they come and bring their presentation next time, we don't come have the same questions. Things are not, find that things are not done. So it is the last question that I have, Chair, that talks to that. In terms of the challenges, I want to see, because we have been given the challenges and the limitations, and also corrective measures. I want to find out to each department that is it possible that we can get the turnaround times on these corrective measures that they will be taking in terms of addressing the challenges emanating from the implementation. Thank you, Chair.
Thank you, Honorable Maseko Jele. Honorable Velma Nieuwoud Drachen.
I'm using a different device, so I hope everybody can see me. Thank you very much for the presentation. Thank you, Chair, for the opportunity. Greetings to everybody on the platform. In relation to the one-stop centers, I only see 3 or 4 mentioned that you reported on. Could you give us exactly where all the child stop centers are situated in South Africa, how many, and where they are situated? And then when children are sentenced or are awaiting trial, where are they kept? Are they kept within correctional services centers, or in juvenile detention centers, or in their homes? You know, maybe you can't give me that information now, but I would appreciate a written response of that. I would like to see exactly where in South Africa these children are kept, you know, and which centers, which types of centers. And then the children who are committing crimes are really getting younger and younger. And I would like to add my voice to Honorable Maseko Jele's question about, you know, the families. What kind of families do they come from, and what are their families doing when the child is, you know, committing a crime? You know, are the parents not available to supervise? Is that when the crimes are made? What decision, or how does the social worker take the decision to release a child to the guardian's care? But how do they know that the child will be under supervision. In other countries, parents are arrested for their children committing crimes. So I'd like to find out how the different departments are assisting the families, what kind of support they give, especially when the child is put under guardian supervision. There is no mention next of the number of children incarcerated and the number of years, the sentences that they receive for incarceration. If you could give that kind of information. And then a huge concern of mine is that the children are not in formal education where they are, when they are sentenced. It is important that children go to school, and in the last term, we heard about the adult prisoners achieving, degrees and matrics and all of that. And how come the children are not receiving that kind of opportunity? So that really has to be ensured that the children who are actually receiving education. And then there's an alarmingly high number of children who are committing rape. Is there investigation or research or finding out why the children are driven to commit rape? And also, are the victims also included in assessing and finding out, how, their trauma and helping them to help supporting the victims in these cases? And also, what is being done to monitor the kind of supervision that the parents or caregivers or guardians are giving these children? And so my last question is the overall number of children who have been incarcerated or charged with crimes. All the numbers that you've presented over the different reporting periods do not mention the number of children with disabilities involved. So if you could give those figures as well. Thank you very much, Chair.
Thank you, Honorable Nivot. Khomotso Ramulube.
Thank you, Chair, and thank you for pronouncing my surname right. Chair, let me welcome the presentation and also make an indication that previous speakers have really touched on a number of matters that I wanted to speak on. Let me finish off from what Honorable Velma has spoke of in terms of the child offenders when they're detained or they're taken to centers, prisons. Are they being encouraged to go back to school? And if they are, what are the numbers that we're currently sitting with? And if you find that there are those who would not want to go back to school, which it's a matter I raised when we're doing the oversight to say, does the DCS have a system in ensuring or enforcing that there's child offenders, when they come to centers, they're in centers, they are taken back to schools, bearing in mind that you would have adults that were being told that doing well and so forth and so on. What happens to child offenders? Because we cannot have a situation where they're just sitting and not going back to school and do nothing. Obviously, when they go back and be reintegrated with their communities, they have a huge chances of going back to doing the very same deed, if not more, before they entered in those centers. Chair, I would not recall on slides, because when I counted the slides, that the report that we were given in terms of slides does not speak or correlate with what the presentation in terms of numbering of slides. So I would leave the slides matter, and I hope they would be able to get from where I'm trying to raise the point. On the top 10 crimes registered on the stats, is it possible for us to get the age difference of those cases or offenders, just to have a clear comparison of what age group would be doing, has committed those crimes on the top 10 crimes that one of the slides was speaking of, Chair. I would also not mention the slide because from my side would say 14, but bearing on the slides that we've been given, it might be something else. What seems to cause the delays to finalize these cases, especially those that are pending, the pending cases or pending matters? What becomes the delay for them not to be concluded? I'd really want to get an answer on that or clarity on that. And there is a matter regarding the training and capacity building, which is meant for SAPS members, especially to make them understand the Child Justice Act. Because you might find that in police stations, when kids go to open cases or there's a matter that involves children and so forth, it gets to be treated differently by SAPS members. Has the training or capacity building for SAPS members started? If not, when are they envisaging that it should take place, and the timelines for that and the timeframes for that? Because I believe it's very crucial and important because of it starts there before it goes to the DSD, it goes to the TCS and the justice system. So what happens within the SAPS framework, especially the HR system that deals with capacity building. On referral of remand detainees, have we started the process of identifying those alternative placements as what one of the slides was speaking on? Have we started that alternative placement of not mixing the remand detainees and those already convicted? If not, what is the delay or remedial action to that aspect, Chair? I've spoken on the education part. I think also Honorable Velma has touched on the matter of centers that these kids once convicted or on remand and so forth, which places are they being put and so forth. I would also like to have an idea on that. Thanks, Chair.
Thank you very much, Honorable Member. I now go back to the department, the leading department, and all other stakeholders. The questions are varied and might have to be answered by different stakeholders. Let me start with the Department of Justice, and then from there you'll indicate who else must respond to questions, and then members at the end might want to have a follow-up on any of the matters. Thank you.
Thank you, Chair. I will start with the first questions posed by Honourable Member Breitenbach on the record, whether we do keep record of recidivism rates and what is the percentage, and also then it's linked to the percentage of children who are diverted, and what is the percentage rate of them reoffending. And unfortunately, we do not have that information currently or as yet. We have not done a study or an investigation to ascertain this, and that is something that we as a committee should be focusing on going forward, taking into account that the Act has been in operation for 11 years now. So we should be looking at that and see how we can improve the gaps or the reasons why children do come back to the system, whether the support and interventions provided in terms of the Act are adequate. With reference to the issue of the DNA, the cases that children that have been acquitted, etc. In the presentation, I indicated that the delay in the finalization of the cases may be linked to the delay in getting DNA results. So the presentation did not depict that children are acquitted because of the lack of DNA results. It just contributes to the delay in the finalization of the cases. And then there was also a comment about the crimes that children commit, the serious crimes that children commit, and we as a we do know that there's a definite connection between delinquency and criminal behavior and the abuse and neglect of children by their parents. And the abuse may be physical, emotional, or sexual. And therefore, there should be a goal, there is a goal, to early identification of abused and neglected children and careful, sensitive handling of these cases to avoid early criminal justice interventions that could become the first in a spiral of sanctions. And then I also want to add that the gender-based violence strategy also highlights children as a target for interventions to ensure that these children, have healthy relationships with other gender and to ensure that they don't perpetrate gender-based violence. Exposure to violence from early childhood, and for boys, it's also being exposed to bullying has been identified by the National Strategic Plan on Gender-Based Violence and Femicide as one of the core drivers of gender-based violence. And one of the key activities included then also include the adoption and rollout of school-based gender violence prevention programs, parenting and early childhood development programs to build non-violent and gender transformative approaches to parenting. So in that regard, there is a definite need to act and to prevent children from committing these violent crimes, because we can see from the top crimes, 6 of the 8 do have an element of violence. So we as a society need to urgently focus on that. With regard to the comments or the questions by Honourable Woon, the National Child Justice policy framework was amended and it was tabled in Cabinet for noting. It was also published in the Government Gazette for comments, whereafter it was finalized and then implemented and printed and distributed. We did do training sessions at all the 9 child justice provincial fora to inform the stakeholders of the changes and what is expected in terms of the collecting of data and the implementation of the different roles and responsibilities of the various stakeholders. But we will also ensure that the correct version is placed on the website, and we will also then embark on more public education and awareness campaigns to inform all relevant parties of the changes that have been effected to the 2010 national policy framework. The issue of the assessments, I think the Department of Social Development will be addressing the decrease in the number of assessments. Then the amendments to the Child Justice Act that where the regulations was tabled in Parliament. The processes that have since unfold, and I will give the South African Police Service and the NPA opportunity to also elaborate on this. But the department has then developed has then developed the regulations in consultation with the various stakeholders when going through all the consultation processes, and the police then have the obligation to amend the national instructions for children in conflict with the law, and the NPA, the directives, and I think they will then inform the Honourable Committee of the progress in that regard. With regard to the question by Honourable Committee Member Maseko Jele, the level of representation at the National Technical Intersectoral Committee for Child Justice, we've indicated that it is senior representatives and it is directors and in some instances chief directors that attend those meetings. With regard to the families of children who commit crime, the Department of Social Development will respond to that question. The question of Dr. Nieuwhout, let me just see. I wrote it down, but I wrote so ugly. Nieuwhout Droegen. There are currently three one-stop child justice centers operational in the country. The one is in Bloemfontein, is the Mangamoon One-Stop Child Justice Center. The one is in Gqeberta, or previously PE, in the Eastern Cape. And the third one is Matlosana One-Stop Child Justice Center in Klerksdorp in the Northwest. Then there was a question about where children are kept while awaiting trial. I will refer back to the presentation. We did provide a slide on where children are kept while awaiting trial, as well as their ages. And in this slide, we indicated that 71% of the children awaiting trial were released into the care of their parents, appropriate adult or guardian. 17% were detained in child and youth care centers, which is being managed by the Department of Social Development, and the majority of those children were 16 and 17-year-olds. 41 children were released on bail, 341 on warning, 40 in police lockups, 49 were detained in correctional facilities as awaiting trial detainees, and there were 10 16-year-olds and 33 17-year-olds that were detained in correctional facilities during the reporting period while awaiting trial. The next question was about the families again, and the level of supervision that families provide and the families that these children come from. This will also be referred to social development. The number of children incarcerated, as well as the time that they spent in incarceration, will be addressed by the Department of Social Development. The formal education being provided in DCS facilities will be also dealt with by DCS, and then in child and youth care centers, the Department of Basic Education is responsible for providing education in child and youth care centers. Maybe the Department of Social Development can add some light to that. And then the next question is the overall number of children with disabilities in correctional facilities with disabilities. I'm not sure if the department, I will leave that question to the Department of Basic Education. The Honourable Committee Member Ramo Puleng also referred to the education of children and the encouragement of children in correctional facilities. The Department of Correctional Services will also address that. The ages of the top 10 children registered on the specific slide, I went through the presentation and that information is not available currently, but I will look at our data and extract that information and then respond to the committee with that specific information on the specific ages of the children who have committed the top 10 crimes registered while awaiting trial. The delay caused in the finalization of cases, I can just here maybe add that indicate that the Department of Justice have included as a key performance indicator in the annual performance plan, indicator focusing on the percentage of child justice preliminary inquiries finalized within 90 days after date of first appearance, and the reasoning for that is to ensure that cases are finalized as soon as possible and that there are no undue delays in the finalization of cases. So we do monitor the finalization of preliminary inquiries, and for the the 2020-21 reporting period, the percentage of cases that were finalized within 90 days stood at 94%. So 94% of the preliminary inquiries recorded by the department were finalized within 90 days. If we detect delays in the finalization of the cases, we bring it to the National Technical Intersectoral Committee where all the stakeholders are involved, because it might be due to delays in police investigation, it might be due to delays at the NPA or within the Department of Justice or with Legal Aid or with the Department of Social Development. But with that information, we are then able to pinpoint where the delays occur and then address those as we become aware of them, to ensure that the cases involving children are finalized as soon as possible. The training of the police will also then be dealt with by the South African police, and then the referral to alternative placement was one of the challenges raised by the Department of Correctional Services, and I'm sure that they will also respond to that issue. Thank you, Chair.
Okay, thank you.
Chair, this is Advocate Praise Kambula. We will now be requesting the other departments then to respond. May I ask then the NPA to start to respond to their questions? Thank you.
Good morning, Chair and all the members. Could I ask that Advocate Vuyo Kutelo, who manages the child justice portfolio of the NPA, to proceed to respond to the questions, please? Thank you.
Thanks, Advocate Kargamo. I would like to respond to the question that was asked by Honorable Horn regarding the amendments of the policy directives of the NPA based on the Amendment Act of the Child Justice. I would like to say that the directives have been amended. They've been consulted with all the relevant stakeholders and within the NPA. Now we're in a process of sending them to the minister so that they can be tabled to Parliament. Thank you, Honorable Chair.
Okay, thank you. Next.
May we then now ask the Department of Social Development to respond to their questions? Thank you.
Thank you, Chair, and thank you, honorable members. The first question is around the assessment. What we are saying is that the Child Justice Act prescribes that assessment by probation officers must be conducted within 48 hours. There are time frames around that. It's 48 hours, and we do have probation officers in all the 9 provinces that are there to conduct those assessments and ensure that we comply with the time frame as prescribed by the Act. And then the other question is around what do we do with the cases of children, or what do we do with children that are not necessarily assessed? Do we work with them or do we assist them? The answer is no. We are not able to assist them because we are relying on the notification by SAPS. If we don't receive notification, we wouldn't know whether the child has been arrested or whether the child has committed crime. So that's why earlier on when Dr. Charmaine was presenting, he spoke about the system issue that needs to be, resolved as soon as possible. So we are working on the system issue as and SAPS. There's a system that we are working on of notification that will ensure that at the end of the day we do get the notification on time, and all the children that are arrested do get assessed on time. Then there's also a question around families, to say what do we do? Do we work with families or we only focus on the youth in conflict with the law? We do, when we do the comprehensive assessment, once a child has been admitted in our facilities, we firstly draw an IDP, which stands for Individual Development Plan. That IDP talks about everything, all the needs of that child, how we're going to turn around his or her life. And then we also do, through that IDP plan, we also do family assessment, because the child is not an island. She comes or he comes from family. So we do family assessment to look at the state of the family and what are the needs of those families. Although we may not intervene comprehensively with the family, but that assessment, it helps, because what we do, we then refer them for further intervention to the social work, to our local social workers. When they have that assessment, then they are able to look at the family needs and put them through the reintegration in aftercare services. So we do work with those families, although not all families are coming on board or cooperative, but we try our level best to do that. And there are programs that are geared towards families. Then the questions around what type of programs do we have for those children in conflict with the law who are in our facilities? We've got quite a number. We've got a category for education. We've got therapeutic programs where we deal with their psychic and everything. We also have education. We also have spiritual programs as well as vocational programs. And the vocational programs, those programs or skills, they are accredited by various sitters. We're not working alone. We are working with sitters to accredit those programs and make sure that once they leave our facilities, especially the sentence one, they then have a trade or they are artisans. So there's quite a lot of effort and time that we put around those interventions. Thank you, Chair. I don't know if I've missed out anything, but I think I've responded to questions related to our mandate. Thank you.
Thank you. Next.
And we now request the Department of Corrections to respond to your questions. And maybe you may also make level of commitment to the committee regarding the issue of recidivism in child offending. Thank you.
Thank you, Chair. For the Department of Correctional Services, I will first focus the question that was asked by Mr. Horn on the amendments of the Child Justice Act and the regulations that were tabled yesterday in relation to the criminal capacity. The Department of Correctional Services does not have any role with regard to the matter on criminal capacity, though we participated in the processes. But when we read the amendments in the Act and the regulations, we didn't have any role. And then the second question that I will respond to, it's this one we advise that we can make a written response, Chair. Where are the children kept in DCS when they are sentenced? So a written response will be submitted, but in the annual report, which is included in the tabled report, we have highlighted the facilities where the children were detained on the 31st of March, March 2021. From time to time, we do the analysis of where the children are. As the number of children is reducing, some of the facilities that used to detain children, they no longer have those children because the numbers are really going down. So, but we will submit a written response. But for both the remand detainees and the sentenced children, the information is included in the annual report. Then the number of children sentenced and the number of years. With this one, I would like to request that also we submit a written information, because we must request this information on all the children that we have reported from our GTO to pull the information from the data bank. Then there was also a question on children and participating in formal education. What happened here, Chair? We discovered that there was, the children were not really participating in formal education. So we did an analysis of the remand detainee children, and we discovered that a lot of them, when they enter into DCS, they were not really involved in formal education. But then we wanted to extend this to the sentenced children. So I think we have to commit to do this analysis this year, just to check what are the causes. Why are these children not participating in this formal education? So I think with the next reporting of the child justice, but it's too late now for 21, 22 this year, because the year is ending. We have not done that analysis. So the analysis, but the number of centers that are detaining children have also reduced. So I've picked up that it's KwaZulu-Natal that has got the highest number. So we will just look at the centers that have got the highest number of sentenced children, and then go and do the analysis of why these children. So the personnel normally interview the children themselves and check their files. So we will be able to say, why are these children not participating? But the opportunities for them to participate, they are encouraged to participate. And then let me come then to the next question. The question on recidivism. We do not have a system for identifying recidivism in the Department of Correctional Services. The only way where we can determine the recidivism is when a person has got the SAP 69. So once we receive the SAP 69. So for the children that are here, we've never checked whether they do have the previous criminal records. And then there was also the question on the referral for alternative placement. The issue of the management of lone children, it was the issue that was raised when the number of children was very high. So we had a lot of lone children that were placed in several facilities. So at these ISCJ structures, we were advised that, can we really look at how we manage these lone children? So I can safely say, Chair, that the number of lone children has reduced drastically, because the number of children have really reduced. There are few facilities, even if you look at the current report, where you see only one child, especially the remand detainee children. But what happens also, because these children are going to court every 14 days, so they don't stay for quite a long time. So in terms of this report, the lone children that have been covered, they are very few. I can say that in Uppington Female, we had one, in Craddock one, Toyando one, and Boxburg one, but they don't stay much longer. So in as much as you would have one, it's not that is the same child that has been kept over a long period of time, because the remand detention population is moving very fast, and since they go to court every 14 days, so it makes their cases to be attended to. I think, Chair, that's all from the DCS side. Thank you.
Thank you. Next.
Now we will be requesting the Department of Basic Education to respond, particularly on the learning programs that are offered at the child and youth care centers. Thank you.
Thank you very much, Chair. Just to respond to the issue that was raised about the learning programs, I think the Department of Social Development need touch a little bit on the different categories of programs that are being offered there, and the category on education and the vocational program category is the one that we find intersectionality with the Department of Social Development on. So previously there was a misunderstanding in terms of the inclusive education policy that we have as the Department of Education, which previously was understood to be a policy that looks at learners with special education needs or learners living with disabilities. And so what we've done, we've canvassed and really advocated for a much more clearer understanding of what the policy provisions are, so that the provincial education departments understand that the inclusive education policy looks at inclusion beyond disability to also then cover learners or children that are in conflict with the law. And so what we've done is to just ensure that there is at least a curriculum framework that is being provided at the child care centers for children who are in conflict with the law, and to understand that if they become, if they're able to come back into society, then what we then do is to, advise provincial education departments to look at a very, focused and deliberate reintegration process, especially if the children are still within that school-going age. Now, the other misinterpretation or misconception that we found was around the provisions of policy when it comes to compulsory education for those children younger than the age of 16. And we've really managed to also dispel some of those misconceptions, and we see now that there is a lot more uptake in childcare centers for children to take up the educational programming. In some instances, Chair, we've also managed to fund the educational programs directly as DBE, which is something that is actually we're not supposed to do in terms of the policy that we have. But because we understand that the right to basic education supersedes all the other, provisions that there are, especially if those provisions do stand against or they counteract the inalienable right to basic education. So what we then do, we then try and assist in as far as possible in some instances, not all, because we know that the majority of them are supported by the Department of Social Development, and ours is to really just provide that curriculum support to it. But where we know that there is slow or no uptake whatsoever of educational programming, we do make that commitment, and it's just a makeshift arrangement that we make when we provide that kind of funding. But in as far as the responsibility is concerned, it lies with the Department of Social Development. So we collaborate on the educational programs then in these centers. Thank you, Chair.
Okay, thank you.
This brings us to the end of the responses to the questions, and we really appreciate the chairperson, the indulgence and the understanding of the fact that these is an interdepartmental reports that we are presenting, and so it's not the responsibility of the Department of Justice to respond to all the questions, and also the fact that you have given us enough time then to present the entire reports. Thank you.
Thank you very much. Honorable members, any drastic follow-ups or urgent follow-ups that you want to do quickly? I will invite that if there are any. Honorable Maseko Jere.
Thank you, Chair. I don't think that I did hear answers on my questions. Chairperson, I had 3 questions. I requested that department must inform us the level of the seniority of the people who are handling these issues. I have a reason why I'm saying that, Chair. We are not here to tick the box. We want to see things happening on the ground, and we want to make sure that something is happening. Number 2, because if it's anybody or any level that is not taken serious, because when people are going to these committees, I'm just giving a background of this, Chair. When they come back and report to their seniors are not taking them serious. I have a reason why I'm saying who is sitting there. The second one, Chair, I did ask about the families. If the information is here, if it's not here, it's fine. They will give us later. But I did ask if the SASSA department, the Department of Social Development, they do have data on the families of these children. the type of families, because we can't deal with the problem if we are not sure exactly who is handling these children at home, Chairperson. And then the third one was directed to our department. Do they have a plan in making sure that their coordination on this department, it gives us good results? Thank you, Chair.
Thank you, Honorable Namatema Maseko Jere, for reminding us about those. Quickly, responses from social development and then justice.
Okay, my sincere apology, Chair, for forgetting to mention that, yes, we do have data on the families that we have assessed, the type of families that we are dealing with. It's, yes, of course, majority, it's family-headed families as well as vulnerable groups, you know, where you find that maybe it's a granny-headed home or it's child-headed home, or, yeah, any other situation that makes them to fall under vulnerable groups. So those are the two types, predominantly families, that we are dealing with when we do the assessment. Thank you.
Okay.
Honorable Chair.
Yes.
Yeah, I'll just deal with the part of the seniority and the level of officials that are dealing with this matter. Advocate Praise Kambule is Chief Director. That's the most senior professional rank in public service. She is responsible for a program called PRVG, Promotion of the Rights of Vulnerable Groups. Then underneath there, there's a director, Dr. Charmaine Badenhorst, who is mainly the director. And these are the colleagues who have been presenting on these issues. But then the Director General of the Department of Justice and Constitutional Development chairs the intersectoral committee that brings the Directors General of the other departments that are here. So that's the level at which these matters are being dealt with. But at operational level, of course, the senior professional is the chief director. With the director, they are all senior managers in the system. Thank you, Chair.
Thank you, DG. Any other additions? None. Okay, thank you. With that, I think those are the final comments, colleagues, on this report presented to us. We note those areas where, and I hope the committee notes that as well, where you're going to have to send us the written, detailed responses on, especially correctional services, on the issues that you committed yourself to do, and perhaps others that wants to make sure that there's completeness in what has been asked. I think as we wrap up, it's important, I want to connect with Honorable Breitenbach and Honorable Jele on the issue that we have a serious situation in our hand. I think Honorable Nivot makes the point that these children are getting younger. And therefore we need to understand, is this about your family units broken down? But the issue there is that this is becoming more of a societal issue. There's no amount of arrest, conviction that will solve this. We need to go beyond this. And I think Honorable Breitenbach, we share your shock and uneasiness about the fact that today this is what we're talking about. In a normal society, we shouldn't. But we appreciate the efforts, the serious work that all of you as these stakeholders are putting into this to confront this problem. But perhaps more efforts are going to be needed, as Honorable Breitenbach said, around the issues of prevention. And those issues of prevention go beyond yourselves as this department. It's about how we create this awareness. We attend to some of the major causal issues And I think that question that Honorable Jele asked is going to tell us where the problem is. And I think it's going to be important that you furnish us with that about these children and their families. What is the driving force here? Is our assumption correct that this could be likely of broken families or what? So you're going to need to give us that so that we'll make our own assessment as to what is it that we really need to do, so that when we get the next annual report, we don't harp on the same issues. We begin to see progress, and progress is not just the resources we put in, the symptoms that we try to manage, but we see a real change. Because some of the slides and information that came here are beginning to show that where you've got a decline in the children that are getting to this space assessment and so on. So it's promising. That's positive. I mean, charges against children that have drastically declined over the years. But I think the major issue is how can we be better preventative, and that's not a justice matter only. That's not a social development. Basic education plays a key role in terms of their own issues and syllabuses. The community in general plays a very important role because you might be receiving societal problems, social ills that are happening there, and you becoming an outlet that receives these kind of issues. With that, colleagues, I want us to pause there and therefore wrap up this meeting. And then for that, I want to thank all of you for your attendance and participation and sharing of this important work. The meeting is adjourned. Thank you.
Thank you, Chair.
Thank you.
Recording stopped.